Our next speaker is the Director of Legal Operations here at SAF. He's a practicing attorney and a graduate of the George Washington University and Widener Law School. He brings 5 years of direct experience in the Second Amendment advocacy space, including the legal director of operations for a liberty-based advocacy nonprofit, as well as a decade of experience in management, marketing, and PR. As the Director of Legal Operations, he is responsible for the oversight of SAF's legal operations to include litigation inception and management, tracking active cases, educating the public, and cultivating SAF's attorney referral network. Let's welcome Bill Sack.
Good morning, everybody. Thanks for being here. I can't see anybody. I can just see a light in my face. That's great. So I'm Bill Sack. I'm Director of Legal Operations here at SAF. What I'd like to do with my time this morning is give you all a bit of a snapshot of what it is we do with y'all's money with our legal program. I think the feather in the cap of the Second Amendment Foundation is our litigation program. I manage that program from inception of cases, deciding what cases we're going to bring, when and where, managing those cases through the pendency of the ongoing litigation, and then figuring out when each of those conclude what it is we're going to do next. So my goal here in the next 14 minutes and 23 seconds is to give you a little bit of an idea of what it is we did this year, what it is we plan to do in the future, and how it is we got here to a degree. So it has been my pleasure to direct the SAF legal portfolio in 2025. The state of the litigation program here is, I believe, as strong as it's ever been. We're currently involved in 51 pieces of active litigation all over the country. We currently, that includes 10 new cases that have been filed since we were all here at GRPC last year, or 9 in the last calendar year. We expect another handful to be filed by the end of the year, so I think we'll easily clear a dozen for 2025, and that's just for new cases. We have made major strides in a number of key issue areas, which we'll talk about. That includes young adult rights, whether it's the ability of adults under 21 to acquire, possess, or carry firearms, as well as the possession rights for individuals who live in public housing, the dismantling of the National Firearms Act, and that's something that we'll talk about, as well as the ongoing hobbling of the California gun control behemoth. We remain firmly camped out on the Supreme Court steps. We are proud to report. We were all certainly disappointed that our Snope case, our melon assault weapons ban case, was not picked up by the Supreme Court last year. But we do currently have 3 pending petitions for certiorari with the Supreme Court, and we'll talk about those cases a little bit. Those are Brown, Lara, and Viramontes, and we'll talk about those briefly. We certainly hope that the Supreme Court chooses to take one of those. Last year in Snope, we got perhaps the strongest indication in the last decade or so that the court intends on taking a Second Amendment case again in the hopefully immediate future. I like to think about our litigation program strategically in terms of 3 primary buckets: the who, what, and where of the Second Amendment. So if you look at the who category of the Second Amendment, we have focused largely on adults under 21 because they, as a subset of the people, face perhaps the most egregious limitations on their rights in multiple jurisdictions around the country. Multiple states limit their ability to acquire firearms, either in total or just handguns, as well as their ability to possess them in some instances, as well as to carry them. So you will see that we have filed, I believe, 8 of our 9 cases that we filed this year alone were on that topic, as well as a few other interesting ones. Rounding out the who category would be our rights restoration cases, as well as our medical marijuana case. Rights restoration cases centering around the issue that we believe that the appropriate test to determine who it is that can be prohibited from owning or possessing firearms are those that have some indicia of dangerousness in their convictions, not folks that have been convicted of nonviolent felonies or other or status crimes like being a user of medical marijuana. Turning to the what category houses all of our hardware cases. Those are going to be our assault weapons ban cases, which I'm sure everybody is keenly aware of, as well as our large capacity magazine cases, as well as critically, just within the last few months, our Brown VATF case, or Brown 2, we call it because we have another Brown VATF case. But our Brown 2 case, which is our challenge to the NFA, as a result of the big beautiful bill passed by the Trump administration, reducing the tax burden on SBRs, SBSs, AOWs, and silencers from $200 to zero. And we'll talk about that in a few minutes. In that assault weapons category, that does include Viramontes, which is one of the cases I mentioned that is currently up on petition for cert. That is our challenge to the Cook County, Illinois assault weapons ban. So essentially Chicago's assault weapons ban, which predates the Illinois assault weapons ban. That case is currently up on petition for cert. We think it's an interesting vehicle for the Supreme Court to address the assault weapons ban issue. And then we do have additionally our Harrell case, which is our challenge to the Illinois state assault weapons ban. And that case was just heard on oral arguments this past Monday before the Seventh Circuit. That is an assault weapons and magazine capacity case. We think that's also a very attractive vehicle for the Supreme Court to take up both those issues, particularly because we have a judgment on the merits in that case and a full trial record. So we have kind of all of the indicia that the Supreme Court might look for to have the fullest possible factual record in order to take up that issue. The last category then would be our where category. Where can you exercise your Second Amendment rights? The largest category there that we have litigation in is in our so-called sensitive locations cases. As I'm sure many of you remember, after the Bruin case came down in June of 2022, all of the typical gun control states that are going to now be dragged kicking and screaming into giving all of the good folks in this room their carry permits decided that they needed to come up with another way of preventing you from carrying your firearms in public. And so what they did was create new legislation that created overlapping patchworks of so-called sensitive location categories, inside of which even permitted individuals were not allowed to carry. So we have ongoing challenges in multiple jurisdictions like New York, New Jersey, California, to those cases, and we are slowly chipping away at the various categories of sensitive locations in which even permitted individuals are not able to carry. The second half of our where category has to do with non-resident permits. In many jurisdictions now that have been forcefully shifted from may issue to shall issue, they are still dragging their feet on making permits available to non-residents. That means that if you happen to have to travel outside of your state into one of these states for business or pleasure, that your fundamental rights under the Second Amendment to carry a firearm for your own protection and the protection of your family and others is eviscerated. We filed multiple challenges in jurisdictions to get those non-resident permits available to folks, and we have been overwhelmingly successful in doing that, including probably most notably our CRPA v. LASD case that's in California. Thank you. In which we have received an injunction that allows SAF members to get a non-resident California carry permit. So that is something that we're very pleased about. And if you go on California DOJ's website, it says right in black and white that you have to be a SAF member to get that permit. So we're thrilled with that. I would be remiss if I didn't take a few minutes to introduce and mention a new key addition to the SAF legal department that I'm sure you guys have heard about a few times from the pulpit so far this weekend, and you're going to hear from him directly in just a few minutes. But we are pleased to have added attorney Costas Moros to the legal department here at SAF. Costas comes to us as our Director of Legal Research and Education. He worked previously at Michelle and Associates in California. He was there for 6 years, where he handled Second Amendment litigation, frequently on behalf of Second Amendment Foundation. Costas is going to be doing 3 primary things in terms of how he educates and does research on behalf of SAF and gets the good message out to folks in a meaningful way. And these are largely his words, not mine, but he will be educating the courts, and this is going to be our widely expanded amicus program. We've taken our amicus brief program in-house by adding COSTIS, and so we're going to be dramatically increasing our output of amicus briefs in cases that are important to staff, but that we are not already a party in. I think already COSTIS has filed 4 amicus briefs on our behalf, and we expect many more by the end of the year, so we're thrilled with that addition. The second way that COSTIS is going to be spreading the good word is educating the current Department of Justice. One of COSTIS's other strengths, in addition to being an internet tastemaker extraordinaire, is that he has a fantastic Rolodex with the Department of Justice and current members of the administration. And we have kind of inside access to the movers and shakers in the administration in a way that we have not before. And we're very excited to be able to have some open lines of communication with the administration and hopefully be able to nudge them in the right direction. We have already seen some pretty significant movement in some ways that I probably shouldn't talk about from the podium, but very valuable, and we're pleased to have COSTIS here in that capacity. And then lastly is educating the public. COSTIS, as you guys probably know, is perhaps best known as a tastemaker, influencer extraordinaire. He has a fantastic talent for taking complex legal issues, whether it's filings or legal decisions, and creating threads on X, detailing them and explaining them in layman's terms. It's something that he's going to be doing both in his in an ongoing capacity on his private channel as well as directly on the SAF X channel. So you'll be seeing a lot more in-depth content explaining exactly what it is we're doing and some of the more nitty-gritty legal doctrine that are indicative or inherent to whatever it is, whatever case we're talking about. COSTIS, of course, as a multiple-year litigation associate, will also be helping me in reviewing documents, planning cases, addressing legal questions, legal theory, doing legal research for us all in-house. All in all, he's a tremendous addition, so we are thrilled to have him. Yes. Looking to the future, we try to strike the appropriate balance with our legal department of being proactive and reactive. As I'm sure you all are aware, as new cases or as cases reach some sort of resolution, the next step becomes apparent and necessary. So we, of course, will be watching the Supreme Court very closely to see if they choose to take up an assault weapons ban case, a magazine capacity case, one of our young adult cases, or a sensitive locations case. If they do, the outcome of that case will largely drive what comes next. In addition to that sort of reactive capacity, we also will continue to be proactive in our ongoing red flag initiative, where we have identified 6 particularly egregious red flag statutes around the country that we're going to be challenging on an ongoing basis, as well as closely watching additional new legislative developments in all of the gun control states that we can all name, I'm sure, and to be poised to challenge those as soon as they might hit the governor's desk. I think it's probably appropriate in my last 2 minutes or so just to talk real briefly about some of the key wins that SAF had this past year, because there were multiple, and I'll see if I can jam a couple in here real quick. In Reese v. ATF, the Fifth Circuit ruled in our favor, and ultimately the ATF decided not to appeal to Supreme Court, that the federal prohibition on FFL selling handguns to adults under 21 was unconstitutional. That's a big win. That case has now been remanded back to the district court, where there's an ongoing battle as to the scope of that injunction. But we're hoping that we get that injunction applied to all SAF members nationwide. That would be a huge win. Critically, that case also creates a circuit split with our other Brown v. ATF case, or Brown 1, which is our case currently up on cert, in which another circuit court ruled against us. So we now have 2 circuits in the United States saying opposite things about the same federal statute. Circuit splits like that are ideal red meat for the Supreme Court to step in and fix that, so that federal law is interpreted the same everywhere across the nation. And so we are very hopeful that our Brown v. ATF case gets taken up by the Supreme Court, and we get this federal young adult handgun purchase ban struck down once and for all. And once you become a legal adult, you can go buy the Glock 19 that you want. CRPA VLASD, that was our California non-resident carry permit case that I already mentioned, but that's a fantastic win. We had a very interesting First Amendment win in a case called Junior Sports v. Bonta. That's a case out of California where one of the strange novel ways that California decided they want to screw with the firearms industry and all of us was by restricting firearms advertising that quote, could reasonably appear to be attractive to minors, unquote, whatever that's supposed to mean. So if you made an advertisement that I guess people under 18 thought might be exciting or might lead them to want to shoot guns, which they are absolutely legally able to do, and their right to do so was constitutionally protected, that California thought that that was a no-no. We got that struck down as a violation of the First Amendment, so we were thrilled with that win. And then another great win out of California was Nguyen v. Bonta, and I think this is a great historical one to end on in my last 6 seconds here, because it's the first case that the Ninth Circuit didn't take en banc and overrule. So in that case, we got the 1 gun a month or gun rationing law struck down as unconstitutional. The en banc court didn't take it and trash our win. And so the Ninth Circuit en banc court, batting 1,000 record, I think it was 50-0 of upholding Second Amendment violative cases is now struck down, and we actually now have a lasting win in the Ninth Circuit. So thank you all for being here. That's what the SAF legal program is doing for you, and hopefully we'll continue doing for you for a long time to come. Thank you.